Judge Fowl continues, subsequently, I issued an unless order on 17th of June 2025. The above paragraphs repeat much of that order. The central difficulty was that Miss Ashwell wanted to continue to conduct these proceedings by email and by video hearing so that she did not have to answer to the warrant. As explained in that order, it is not part of the Tribunal's function to assist a claimant in evading the police, and she was directed as a minimum to provide to the Tribunal her current address. That is an essential requirement of every claim that is submitted. The order also advised that the next hearing would be a public hearing to be held in person at Croydon, and that the hearing would be to consider whether to strike out the claim, and if not, whether to amend her claim to include these new allegations and generally for case management. The Tribunal's assertion that I sought to evade the police is false, misleading, and defamatory. The criminal cases against me were fabricated and appear to have been orchestrated to intimidate and prevent me from further legitimate employment and criminal claims against the respondent, including constructive dismissal, sex discrimination, bullying, harassment, rape, collusion, and perverting the course of justice. Contrary to the Tribunal statement, I did provide my current address with a clear request that it remain confidential. It appears that the respondent nonetheless requested access to my physical location, and my previous West Midlands address was disclosed. This raises serious concerns of collusion and intimidation and is not relevant to the Tribunal's management of the case. Providing my address was fully compliant with the Tribunal's unless order, in accordance with Part 16 of the Employment Tribunal Rules of Procedure 2013, which requires claimants to provide their current address, there is no legal requirement for the Tribunal to disclose this to the respondent. Despite compliance, the Tribunal held the hearing remotely only for the respondent, while I was denied access, directly violating Rule 3 of the Employment Tribunal Rules of Procedure 2013, which mandates fairness, impartiality, and equality of arms between parties. By contrast, other claimants, including one against Peter Shakeshaft, who relocated to Sweden during proceedings, were granted remote participation without issue, showing inconsistent application of procedural rules. It is also outside the Tribunal's remit to interfere with police proceedings or suggest that a claimant must comply with ongoing criminal investigations in a way that prejudices their civil rights. Employment tribunals are not empowered to assist in law enforcement actions, and any suggestion that I was evading the police mischaracterises my conduct, undermines my credibility, and prejudices the tribunal against me. Furthermore, Rule 47(2) of the Employment Tribunal Rules of Procedure requires that any explanations for absence or inability to participate must be considered, yet my documented reasons, safe participation via video and remote access, were ignored. This is a clear breach of procedural fairness and shows bias in favour of the respondents. Taken together, these points demonstrate mischaracterisation, procedural unfairness, and apparent bias, reinforcing that I have legitimate grounds for appeal under Rule 68 of the Employment Tribunal Rules of Procedure and for judicial review on the basis of unfair treatment and denial of access to justice. It's probably also worth mentioning here that the respondent requested a number of times that certain hearings be held remotely, and they were granted remote hearings. So there's obvious bias there as well, apparent bias there as well. Their requests were granted and mine were not.